All right, folks, I am going to bring this meeting back to order because I do not want to steal any time from our esteemed afternoon panelists. I will acknowledge in lieu of a roll call that everyone from this morning is here, although Nancy Lamond had to leave and has given a proxy for her vote this afternoon, and that Sandra Peters joined us towards the end of the panel this morning. Our next item is the afternoon panel regarding materiality, and I welcome you, James, to go ahead and kick it off. And I want to reassure you that the 8 or so minutes that we're missing will be added to the end, so no worries. Over to you.
Thank you much, Chris. Good afternoon, commissioners, distinguished panelists, fellow members of the IAC, esteemed guests. Welcome to this panel discussion on materiality. Today we have gathered here to delve into some key aspects of materiality and its impact on financial reporting and decision making, while acknowledging that this year will mark the 25th anniversary of an important piece in the materiality puzzle, Staff Accounting Bulletin 99, Materiality. Materiality is an important topic, especially during this period. I note that the SEC Historical Society recently held a panel discussion on the history of materiality, which is available on its website. I must also note that yesterday, the SEC issued its final rule on climate disclosures, mentioning materiality over 1,000 times. It appears to be the hardest working word in disclosures. Materiality, as stated in the seminal TSC versus Northway case, refers to the concept that an omitted fact is material if there is a substantial likelihood that a reasonable shareholder would consider it important in deciding how to vote. Consider it important in deciding how to vote. TSC goes further and explains, put another way, there must be a substantial likelihood that the disclosure of the omitted fact would have been viewed by the reasonable investor as having significantly altered the total mix of information made available. Seems straightforward, right? It is. However, the same standard applied in the 14A9 context is also applied in numerous other contexts where the analysis may be less straightforward. In today's rapidly evolving business landscape, where financial markets are becoming increasingly complex and interconnected, the role of materiality and the guidance provided by SAB 99 are more crucial than ever. We must remain vigilant in ensuring the accuracy and integrity of financial reporting, protecting the interests of investors and the public. Materiality has a critical role to play in this undertaking. Throughout this panel discussion, we will explore various dimensions of materiality, including its interpretation and application, as well as its evolving role in the context of emerging issues such as sustainability reporting and non-financial disclosures. We must note that our panelists were not made aware that there would be a 900-page final climate rule issued a day before our meeting. Nor was the rule a part of required reading for this panel. In fact, though we run wide, our lane will center on the SAB 99 journey. We are honored to have a distinguished panel of experts with us today who will share their insights, experiences, and perspectives on materiality and its impact on financial reporting. Their expertise will shed light on the challenges, best practices, and future directions in this critical area. Our panelists include John White, Partner and Chair of Corporate Governance and Board Advisory Practice, Cravath, Swaine & Moore, LLP. Online, Professor Joseph Grunfest, Professor of Law and Business, Emeritus Senior Faculty, Stanford. Professor George Georgiev, Associate Professor of Law, Emory University. Professor Preeti Chaudhry, Professor of Accounting, Eller College of Management at the University of Arizona, and Lynn Turner, Senior Advisor at Hemming Morris Forensic and Financial Consultants. Before we proceed, I would like to express our gratitude to all the panelists for their valuable time and contributions. I also want to extend a warm welcome to all the attendees whose presence and engagement make this discussion all the more enriching. Without further ado, let us dive into this captivating discussion on materiality. I first turn to John White. Mr. White formerly served as Director of the Division of Corporation Finance of the SEC. He regularly advises companies on critical materiality matters in his current practice. I had the pleasure of serving with John on the Financial Accounting Standards Advisory Council. John, would you begin our discussion by sharing some initial thoughts on materiality?
Thank you, James. I'm very happy to be here today. As I think you know, or if you figured out from the introductions, I'm the only non-academic on the panel. So let me just say I was a little bit intimidated when James said that I had to give a scholarly background of what was going on here, but I'm going to try at least. So first, consistent, comparable, reliable disclosure is at the core of our securities laws. Materiality is a fundamental concept embedded in the disclosure regime. Or to use the words of Chair Gensler yesterday, it's a bedrock principle. I guess not just yesterday, but earlier today here. So in effect, materiality provides a screen so that relevant disclosure goes through to investors. I mean, that's kind of where materiality fits in. James, you started with the cases, but I will mention them as well. 48 years ago, in 1976, the Supreme Court laid out the definition and the principles in the Northway case. That involved, as you said, a 14A9 proxy voting context. 12 years later, in 1988, those principles were repeated in the basic decision, which was a 10b-5 merger disclosure case. And most recently, the Supreme Court reaffirmed those in the Matrix decision in 2011. So you got three cases that basically say the same things, I would say. So the principles. Information is material if, three things, there is a substantial likelihood that, second, that a reasonable investor, third, would consider the information important in making a voting or investment decision. Or said another way, if the information would have significantly altered the total mix of information made available. Notice I underlined the word would each time I said it. Those same words, or at least similar words, have shown up in the SEC's definitions under the 33 and 34 Acts. They've shown up in the accounting and auditing, from the accounting and auditing standard setters, both FASB and the PCAOB. You will find them in remarks of senior SEC officials, CorpFin, enforcement, chief accountant, all using similar words. And you find them in recent rulemakings, as you said, 100 times, they didn't show up 1,000 times. Oh, by the way, I brought my copy of the release here. It's actually marked in yellow every time the word material shows up. I have not read all of it, but you know, it does show up 1,000 times. I think it is fair to say that these Supreme Court definitions have stood the test of time, and they're clearly the law of the land today. So, a couple of observations. First, it's an objective standard. This is all from the cases. Second, it is a company-specific standard. You need to evaluate all the facts at each particular company. And I'm actually going to read you one piece from page 19 of the release, because it's right up here at the front. Materiality refers to the importance of information to investment and voting decisions about a particular company, not to the importance of information to climate-related issues outside of those decisions. So the release says it's decisions about information about that particular company. When you're making decisions about that, that's what you're looking at. Second observation, it's a would standard, not a could standard. In the Northway case, the lower court actually used a could standard or a might standard, and that was overruled. The actual words from the lower court decision was that material facts include all facts which a reasonable shareholder might consider important. And the Supreme Court said that's not the definition. The Supreme Court said that, explained in part, that the reason that they wanted a would standard is because this would avoid having management bury shareholders in, and I quote, an avalanche of trivial information to avoid liability. So this is all the Supreme Court in these cases we're talking about. I know Lynn is all set here to give you a lot more on the law, and I'm sure, Lynn, you'll be much more scholarly than I am, but we'll get you'll get to you in a moment. Okay, so now that's the background on the law. A couple of personal observations. As James said, I've spent decades advising public companies and working with accounting firms on making materiality judgments and crafting the related disclosure in advance of it being tested. At least when I've done it, I don't have the benefit of 20/20 hindsight. I advise up front. Academics and courts get to look at it after the fact, but my experience is looking at it up front. A lot of my time, probably most of my materiality-related time, is related to materiality in financial statements, which is what this panel is about. Remember that Supreme Court decisions were not talking about financial statement materiality. They were talking about it in other contexts. So the thing that happened that was very convenient for anybody who's looking at financial materiality happened in 1999 with SAB 99, which was providing materiality guidance with respect to financial statements. And of course, Lynn's going to talk about that because Lynn was I don't know, Lynn, I'd written down you were the craftsman of it. I don't know, maybe more than that. In discussing it with you, it was a lot of effort and a lot of time. One of the things that Lynn pointed out to me was look at footnote number 1. So I will give us context. Footnote number 1 says the purpose of this guidance is evaluating materiality of misstatements identified in the preparation of financial statements or the audit process. And it specifically says, Lynn, these were your words, I guess, it was not intended to provide definitive guidance in other contexts. So that at least is the way Lynn set it up. This is 799 was for financial.
Yeah, I did write that sentence.
Okay, well, okay. All right. So what does SAB 99 do? It builds off the Supreme Court cases, but it adds one very critical addition. It notes that the size or magnitude, the quantitative amounts, is only the starting point. You must also look at qualitative factors to determine if a quantitatively small amount, which would otherwise presumably be immaterial, may become material because of qualitative factors. And then it goes on, the 799 gives you a whole list of non-exclusive factors to look at. I would say, quite nicely, it has also stood the passage of time. I mean, we're 25 years later. In preparing for this panel, I looked at all those factors that are in there, and I ask a lot of people, including the panelists, are there missing factors or outdated factors? And in all candor, I'm not seeing or hearing suggestions that the guidance, the factors that are in SAB 99 came up short 25 years later. I mean, I think that I'm hearing the factors are there, and the one thing that I guess I have felt is that, and what I'm hearing in some cases, is that there may be issues with respect to implementation. I know Preeti's going to drill down on one of them in particular. So as we progress today, I don't think you're going to come away thinking we should be changing SAB 99 in terms of redoing it. I think you're more likely to come away that there are places where we could think about implementation guidance. But obviously, you know, that's the purpose of why we're all here. So that's my opening remarks, James.
Thank you very much, John. Next, I would like to turn to Professor Grunfest. Joe is a nationally prominent expert on capital markets. He's a senior faculty member with the Arthur and Tony Rock Center for Corporate Governance at Stanford. Before joining the Stanford Law School faculty, Professor Grunfest served as an SEC commissioner. Joe, you have taught materiality in law school and have seen it applied in the real world and have been involved in making materiality decisions. What do you see as obstacles or misunderstandings that companies encounter when applying materiality in practice? How can these be addressed?
Thank you very much for the invitation, James. Hello, everyone. Sorry that I can't be there in person because of other commitments. Let me start by giving a little bit of a broader context in terms of how I approach this problem, which is going to be different from the way everyone else on this panel approaches the problem. I've lived and breathed the challenge of materiality from many different perspectives. I've served on the audit committee of 3 large publicly traded corporations. Most recently, I chaired the audit committee of KKR for more than 13 years. I was also a co-founder of Financial Engines and served on its audit committee for its entire public lifespan. And before that, I was on the audit committee of Oracle. I've probably reviewed thousands of materiality determinations. I've taught the concept of materiality in securities regulations courses, and I've written about the concept of materiality. But most important, I've learned when to ignore the concept of materiality and when to say, I don't care about materiality. And let me focus or dilate on contexts in which it's critical not to care about whether something is material and to address issues that are possibly very clearly sub-material for one very simple reason. There is, unfortunately, a parallel between the analysis of materiality and the subject of oncology. We all know that for certain forms of cancer, if you catch them early, you can cure them. All right? You can cure them. The same is true for many material problems, not for all. There's some material problems that just explode on you, and there's nothing you could have done ex ante in order to control that risk. But in other contexts, these problems start small, they grow, and they metastasize. If you catch a problem when it is sub-material, there are often situations where you can fix the problem and prevent it from becoming material. And one of the problems that I perceive in the advisory environment and in many other environments is that people find a problem, they go, oh, it's sub-material, let's not worry about it. Big mistake, huge mistake. When I would find a problem, the problem is sub-material, I look at it, I go, great. What is the odds? What are the odds that this problem, which is today sub-material, metastasizes and grows in the future so that it then becomes a real problem? Further, organizationally, when bad things happen, employees sometimes hide the bad things from their superiors and from the board, and their rationalization is, well, it isn't material, therefore I don't have to bring it to their attention. The most notorious example of behavior of that sort that's publicly known is probably Wells Fargo, where they were opening up all of these false accounts. But management looked at the data and said, you know, given our size, and we're enormous, we're ginormous, you know, we only have like thousands of these accounts, all right, that have been falsely opened, when we have millions and millions of other accounts, therefore it's not material, we don't have to bring it to the board. Disastrous thinking. Absolutely disastrous. And one of the problems with materiality from that perspective is that if people focus on that concept too much, they miss the opportunity to solve problems before the problems become far too large. So, in addition to having a clear notion of when a problem is material and when isn't, and the law governing what is material and what isn't, you need to develop, if you're working with a corporation, you're on an audit committee or advising an audit committee, you need to develop a protocol that helps you understand when you have to attack a sub-material problem before it becomes material. A couple of things to think about along those lines. One, these problems are sometimes qualitative and they're sometimes quantitative. Qualitative issues. You know, we got somebody stealing some money, it's $50,000. This is a combination of qualitative and quantitative. Somebody's stealing some money, it's only $50,000. $50,000, clearly immaterial. We've got $500 billion of assets. No. What is it in the systems and procedures that would allow somebody, in effect, to steal $50,000 from the company? If they can steal $50,000, why couldn't they steal $500,000? If they could steal $500,000, why couldn't they steal $5 million? What is it that allows that problem to come up? Second, a problem that comes up constantly in many different environments: spreadsheet mistakes, spreadsheet errors. These are honest mistakes. Nobody's trying. It's, somebody's working late at night and they transcribe a number wrong, or they forget to put in a minus sign, and you wind up with a mistake. This happens all the time, and this mistake can work its way through the financial statements and people don't figure out, and you wind up with a bad number. Do you have enough eyeballs on the situation? Do you need to throw more resources at double checking? There are all sorts of techniques that can be used in order to make sure that these mistakes don't occur. So when you find a mistake of that sort, and it's only for $1 million and the company's reporting $1 billion, it would be really easy to have another zero in there and the problem becomes 10 times larger. There are many, many different techniques and approaches. Many of these techniques and approaches have to be customized to the specific situation. And my advice when looking at the concept of materiality is to be very clear-eyed, because sometimes materiality will cause more problems. Focusing on the question of whether something is material causes more problems than it solves, because it gives you an excuse not to address an issue when the issue must be addressed before it grows. That's all I got to say.
Thank you very much, Joe. I will next bring Professor George Georgiev into the conversation. George is a scholar of business law examining topics at the intersection of corporate governance and securities law. He has prominently written about two of sustainability's primary components: environmental matters and workforce-related matters. He also recently testified before a House Financial Services Subcommittee on the SEC's climate proposal. George, we have discussed materiality in litigation and important Supreme Court cases. Would you share some thoughts on materiality at the rulemaking stage?
Thanks, James, and thank you for inviting me. It's a pleasure to be here. In some ways, my remarks will echo Joe's remarks, but in a different context. And I think sometimes materiality, a particular version of materiality, is overemphasized in the rulemaking context, and we perhaps put too much faith in what the Supreme Court's definitions of materiality or articulations of materiality can achieve. So obviously, the concept of materiality is fundamental to securities law, but its meaning and the way it is operationalized is always contingent on context. It's important to remember that the Supreme Court's succinct articulation of materiality is helpful as a general matter, but it is when it put forward this articulation, the Supreme Court was addressing the question of whether an issuer at some point in the past, some specified point in the past, had a legal duty to disclose particular information under a particular set of circumstances and in light of the applicable regulatory framework. In other words, the court's materiality test applies to an ex post liability determination and not to an ex ante policy choice by a regulator. And when the Securities and Exchange Commission makes decisions about whether to require disclosure of certain matters, climate-related risks, emissions, it is by definition looking prospectively, and it cannot. It doesn't have the benefit of hindsight to determine whether there was some indicator of materiality that then would impose liability. And so courts, even courts, which do have the benefit of hindsight, often struggle with materiality and liability determinations with, again, the benefit of hindsight and with evidence of price impact, which is what they most often use. And so my point is that we shouldn't look at the elegant and succinct definition that the Supreme Court put out and think that that can answer the specific question of whether or not the SEC should require something to be disclosed. And then I can make one additional point, which relates to the difference between materiality and universal materiality. And so we have heard in recent years arguments that for the SEC to require something to be disclosed, it needs to be material in every single point in time for every single company. And that is kind of the standard for when the SEC should require something to be disclosed. But of course, that is just too much, that is an impossible task to achieve because, first of all, there are epistemic problems of knowing what will be material for every single company at every single point in time, and very few things will be material for every single company and at every single point in time. And materiality is contextual and relative, so those decisions need to be made on that basis. So I'll pause here and turn it back over to you, James.
Thank you very much, George. Now we're going to get back into financial materiality. As John initially pointed out, materiality determinations are made in the financial reporting context. To address such financial reporting issues, we have Professor Preeti Chowdhury. Preeti is an expert on materiality in accounting and has written extensively on the topic. Preeti, would you please share what you have found in your studies, including areas that deserve attention?
Thank you, James, and it's an honor to be here today. So my views on materiality are largely formed by studying large sample data empirically and decisions that are made by managers or by auditors, and sometimes looking at subsequent share price reactions as a proxy for investor views. And I have 4 studies that I shared with the panel, and hopefully they were shared with the full group. But I'm just going to summarize a few findings. First, materiality judgments are pervasive within financial reporting and vary substantially. They have important implications for the reliability of financial reporting. Second, the discretion in materiality largely stems from the notion that this judgment requires context, and because of that, it can be exercised opportunistically. Third, small and immaterial errors do grow in significance over time, consistent with Professor Joe Grunfest's comments, and they increase the likelihood of material errors. Finally, there's an unfortunate common practice of managers not addressing immaterial errors ex ante when identified, and these can come back to haunt them, also consistent with Professor Joe Grunfest's comments. So a few thoughts on why the materiality judgments are confusing and some corresponding suggestions or questions to consider. There is confusion about what the term context means in materiality judgments. FASB 2018 standard says it is entity specific. Some people think this means varying judgments on quantitative materiality or qualitative factors that should be considered. But context can mean other things. For example, what role, if any, should relevance play in a materiality judgment? How should one think about netting individual errors? A recent article in AJPT that looks at internal audit firm guidance mentions that auditors often consider whether errors can be offset in judging materiality. But should they? The bottom line is there's a lack of guidance on the implementation of materiality concepts, specifically how to think about the context. Secondly, materiality judgments are made at different points in time in the financial reporting process, and therefore they differ in nature. For example, in practice, auditors start the audit by establishing planning materiality, which is a quantitative threshold set at the beginning of the audit meant to guide and plan the audit. Then they consider both quantitative and qualitative factors that are used to evaluate the importance of the errors at the end of the financial reporting process. In addition, auditors often use something called tolerable error, which ranges from 50 to 90%. It's the notion that there should be a cushion around that quantitative number. So, for example, if $50 million is judged to be quantitatively large, maybe then we should be disclosing items or using in our audit something that's 80% of that, right? Because we don't want to get near the big number. So I believe a revised standard on materiality could formalize the process that management takes to think about materiality that could follow somewhat like the approach auditors take. Initial judgments could be used to guide the disclosure process that could be largely quantitative with a cushion. Then additional consideration for omitted disclosures should require an application of qualitative factors that could elevate otherwise immaterial things. If formalized, this would facilitate disclosure in perhaps summary of significant accounting policies so that investors would know what amounts managers considered to be material. Another way to consider the disclosure could be something that follows the UK, which requires the auditor to disclose quantitative materiality used in the audit and their basis for it. Third, my research finds evidence suggesting that auditors and managers may be using qualitative factors to judge quantitatively large values as immaterial. A revised standard could explicitly address that interpretation. Generally, this speaks to the issue of diversity of practice, perhaps stemming from insufficient guidance and or insufficient training. And addressing implementation issues using speeches is not ideal. Formal guidance is necessary that goes through sufficient due process such that language can be less likely to be open to misinterpretation. There's a general confusion about how to think about materiality, specifically in the context of fraud. I think Joe mentioned earlier, specifically the Wells Fargo case. I think it is not that uncommon that immaterial errors related to fraud don't get elevated. So if one was to consider any reason to revise SAB 99, one possible thing to consider is that fraud could be added as a contextual factor to emphasize that it should be considered differently than the typical qualitative and quantitative process. Other examples one could think about if one was to revise SAB 99 might be to consider the issue of ICFR and the existence of potential material weaknesses or significant deficiencies, as these were significant revisions to the financial reporting process made since SAB 99. Managers are pervasively waiving corrections to financial statements identified by the auditor. This is what I find in my research, and that these errors tend to persist. Why isn't there more attention paid to correct these underlying cause of these errors? Why is it that the auditor and the audit committee oversight isn't working well enough here? One possibility is to consider requiring companies to disclose errors identified by the auditor that remain uncorrected and let the market pressure them to do the right thing. Thank you.
Thank you very much, Preeti. Now we will go for the first time to Lynn Turner. Lynn was the chief accountant of the SEC 25 years ago and one of the principal authors of SAB 99. So Lynn, upon reflecting on SAB 99, what are your top line thoughts on materiality in 2024? And knowing what you know now, is there anything you would have done differently? How could the guidance be improved?
Well, something's either material or it's not. I grew up on a farm, so I come at this slightly differently too, from a common sense perspective. But I think you have to understand some of the history here, some of which John talked about. And let me start out, though, by saying everything that Professor Grunfest said was marvelous, and he's spot on and correct in many situations. It's not an issue with the law. It's not an issue with the rules. It's not an issue with SAB 99. Most of the issues with materiality, which I've dealt with for the last 45 plus years, is an issue of oversight, governance, accountability, and enforcement. And the way we got here, though, you have to understand that to know where we're going. Back when we had the stock market crash in 29, people deserted the marketplace. That sell-off was phenomenal, and we never had that level of trading in the market again for the next 39 years. It was that devastating. So the Senate decided to hold hearings in 1932. They were not very successful, so they brought in a new, sharp deputy attorney from New York by the name of Pecora. And Pecora started hearings in 1933 that were phenomenal. And he brought in Charles Mitchell from City National Bank in New York. He brought in J.P. Morgan. He brought in Wiggins, the head of the stock exchanges. And he did a marvelous job of getting evidence from them and then cutting through what had really happened. And when you read the transcripts from the Pecora hearing and the report, what came out was we had people who had made misstatements of fact time and time again. And we also had people like Mitchell admitting that there was very significant, important facts that had never been told to the people that were investing in his and others' companies. And as a result of what Pecora found, the Senate turned around with Pecora and then crafted the 33 and 34 Act, which has a couple key terms in it. They obviously have, as I think John mentioned, language in there with respect to a material misstatement of a fact or an omission of a material fact. And that arises directly from those hearings. And you'll see that lifted up. So when they lifted up and drafted the law, the 34 Act and the 33 Act, and brought in the word material, they lifted material from what existed at the time in the common law. So it was intended and meant in that law to be the common law definition of materiality. And the same thing happened with respect to reasonable person. And they lifted that, though, out of the definition that was in existence in tort law at that point in time. Let me just read you, get the flavor for this. The common law definition of material, having some logical connection, as a farmer I like that, logical connection, having some logical connection with consequential facts and material evidence of such a nature that knowledge of the item would affect a person's decision-making, significant essential material alteration of the document. And when you think about that in the language we have today, it's pretty much the same language. It's from a common sense perspective, what would a reasonably prudent type person do? And with respect to reasonable person, they turned around and said a hypothetical person used as a legal standard, especially to determine whether someone acted with negligence, specifically a person who exercised a degree of attention, knowledge, intelligence, and judgment that society requires of its members for the protection of their own and others' interest. And that's where we got this into the law. And it comes into the law in 33 and 34 Act, and there's plenty of congressional history that cites how this came into the law and act, and that's what is intended. Congress also states in their legislative history that the whole intent was to do this all through disclosures and open up the sunlight. And that goes in, and almost immediately by 1934, before the year's even out, the first year SEC, they have their first case on this. It's with respect to Charles Howard. And they have their initial case on this, and they come up with a discussion of materiality that's pretty much what we have now. It says a fact which, if it had been correctly stated or disclosed, would have deterred or tended to deter the average prudent investor from purchasing securities in question. And that's the first case that comes in what the court SEC itself says. And then we move forward, and as John mentioned, there's cases in the 60s, 70s, from some extremely well-known judges, Judge Friendly out of New York, and then we get into Judge Thurgood Marshall, and he writes the 76 TSC opinion, and it's marvelous. Absolutely a fantastically written document. And in that, he notes the point that John noted earlier, that we have this notion of a reasonable man, and he says that law comes, two of the lower circuit courts had said a reasonable man is from the tort law. And Marshall agrees with that. The circuit court that John referred to got it wrong. But Marshall accepted that common law definition and actually refers to it in the opinion of the court. And that sets it in black and white, because believe it or not, folks, a Supreme Court decision, whether you agree or not, it is the law of the land. And once that law is put in place, the SEC cannot, by rule or regulation, change that law of the land. It is what it is. And unfortunately, my experience has been most people, and maybe it's a good thing, but most people don't go read all these Supreme Court decisions and all the print in them, and they're marvelous. But the one by Marshall was super, and as I think James mentioned in the TSC case, it did deal with the proxy, but then 12 years later in '88, Justice Brennan writes another marvelous opinion. And he says, Justice Marshall was so right. It was so good. We are once again going to adopt Marshall's opinion as the law of the land. And that's what's written in the basic decision then in 1988. But they make some important things. They say materiality depends on the facts and thus is to be determined on a case-by-case basis. There is no materiality law that gives you the same answer for each company. It depends upon the company. It has to be an objective decision. It has to be made at a point in time and based on the facts at that point in time. The opinion actually says there's to be no 20/20 hindsight notion with this. And in the basic decision, Brennan says it's not just with respect to proxies or an acquisition or whatever. We're also going to apply it to Section 10B and 10B5. And so it really becomes broadly applied for the most part to all law. And so we've got that in place, but we get into the corporate scandals, Enron's, Adelphia's, WorldCom's, whatever they are. It was exciting times here. Paul Roy and I were both here together. He was a hellraiser, I tell you what. He had people's attention. Yeah, really. You know, so, but we were seeing all these problems with people misapplying the law. And so we said, okay, we'll take one more shot. We're not going to write a rule, though, because the rule was in all the court law. So, and the courts actually said, you can't have a bright line. There is no bright line test. We will not accept in the courts a bright line type test. Make it clear. In fact, as I'm working on SAB 99, Arthur Anderson sends me a letter and comes and meets with me and says, Lynn, you got to make it 5%. And yeah, exactly. That's how my eyes looked when Anderson said, yeah, 5%. He's above, you know, you're out. You got to bucket it. Below, you're good. And we rejected that because we couldn't do that. The law said you can't have a bright line test. It has to be dependent upon the facts and circumstances. And ultimately, would you make a different decision as to buy or sell the stock? And as John said, it's would, not could, not maybe. And it was Marshall that said it is would. So that's where we're at as we're doing 99. We see all these corporations and auditors playing games with the numbers, as Preeti mentioned. And the auditing profession had started a task force 6 months before I even got to the commission. And they come up with a great list of qualitative factors. And I met with them. They put out a report on it. I liked their list. We met with 50 different groups of people at the time. Not one, not 10. In fact, one day I got to the office and there was a CNBC truck out front. And I walked around to them and I says, what are you guys here for? Well, you've been having so many meetings, we thought we'd just park out front and wait to see if anyone shows up today. You know, we were having these meetings with companies, investors, auditors, lawyers, and we got everyone's thoughts on what would come out, what should be in a qualitative list, and we put that into SAB 99 in the first part. At the same time, we met with the chairman, vice chairman at the FASB up in Norwalk, and they expressed to us the exact same concern in 1998 that Joe, you just heard Joe talk about, and that's why Joe is so right about what he discussed, and that was people start with small numbers and they start down that slippery slide using small numbers that snowball on them and become big numbers, and then voila, section 10b5, you got a problem. And so we actually put language in there because we saw that at the SEC as well. And there's language in SAB 99 that actually says you can't do that. So what Preeti described her findings were, there are already language on the books that says you can't do that. Now, if people choose to do it, it ain't changing SAB 99, it's doing enforcement actions in that regards. And so we put the SAB 99 together, put it out in August of 99, and there's a court case going on at the time called Citizens versus Gardino, a utilities case, utility company, and the issue's materiality. And the lower court holds that it's not material. The commission disagrees with that, and so do the shareholders, and they appeal to the appellate court in the 2nd District in New York. In October of that year, the commission files a brief. The commission votes and approves the brief to be filed with the court. And the brief states that the SEC is adopting SAB 99, even though it's a staff accounting bulletin, that they're adopting it as what they believe is the proper guidance. So it's not just staff guidance. And then it goes into the appellate court. And the appellate court takes a look at it, and in a way, in a strange decision, the appellate court says SEC staff accounting bulletins constitute a body of experience and informed judgment. SAB 99 is thoroughly reasoned and consistent with existing law. So the most important appellate court when it comes to security matters turns around and says SAB 99 is exactly what the law is.
So Lynn, is there anything that you would have improved upon?
Let me finish. And in the court's decision, you have to consider both quantitative and qualitative factors. There is one thing that I could kick myself in the butt, that if I had it to do over again, I would do not differently, but I would add onto it. And that is about 2 weeks after we issued it, I got a letter from a great professor out at Georgia Tech that said, Lynn, when you do SAB 99, make sure that you require disclosure of a company's significant accounting policy for materiality. And GAAP, FASB rules do require that a company disclose its significant accounting policies. But over time, some companies, actually a lot of companies, have avoided disclosing a particular significant accounting policy unless called on the carpet, and materiality is one of them. And in 2013, in the UK, for companies on the markets in the UK, so the London Exchange and the AIM Exchange, the UK adopted a new rule. And the new rule says that the auditor has to state in their audit report two things. First, they have to state how they determine materiality. So what was the basis for making that determination? And they're going to tell you about that. And the second thing they're going to tell you is how much is it? What is the material number, which is the crux of the issue? Because we got people that either want the number higher or want the number lower. And it's usually for their own agenda, not necessarily for investors. But the UK started requiring that. They've had it in effect now for over 10 years. It has worked exceedingly well, and the disclosures are marvelous. And because you see the number and the thought process that went in to arrive at that number, you can make your own assessment as an investor as to whether they got it right or wrong. But more importantly, if you see a number that you disagree with, then the market itself can bring discipline to the issue. And so you think back to why Congress originally did that 33 and 34 Act, it was to bring trust to the market. So we give them that number. So then the market, if they think it's too high, can bring pressure and discipline in itself and enforce what's in the rules. But it's not an issue with whether or not the rules have enough guidance. I think the rules are done, and I would never suppose that I could write a better rule than Thurgood Marshall, you know? And I'm not sure I'd want other people holding that pen either. I think he did a great job. So unless you think you're smarter than those who have come before us, who've written those laws that have stood the time, Justice Marshall's opinion's been around since '76, so 50 years, and it's been applied. And when we did SAB 99, by the way, we had a nationwide video conference call with about 500 participants, CFOs, controllers, accountants, and auditors on it, and they did a survey. 84% of the people said SAB 99 was useful guidance, and 83 to 84% of the people also said it would not impact how they closed the books. It was consistent with what they were already doing. So our problem is with that outlying 15+%, which seem to always be out there, and that's, I think, really an enforcement issue. And again, the SEC can't do this via rule or regulation. This will have to be done via a congressional act.
Thanks very much, Lynn, for that history. Yes, John.
Yeah, since you made me go first, I wanted to react quickly on a couple of these. First, I agree with Joe entirely. I advise audit committees every week, every month, and yes, you should be looking at small issues. That one's really easy. George, you were talking about the materiality in rulemaking. The SEC, generally speaking, and including in the climate release, says that the release, the rulemaking is grounded in materiality. There's lots of rulemaking where every single item is not itself material. I mean, I'm thinking back when I was on the staff, the principal rulemaking we did then was the executive comp rulemaking. There are tons of pieces in there that individual pieces of them are not material, but if you were judging it under the Supreme Court test, but the package was certainly material, or pieces of it were. But the thing that's interesting about the climate release that came out yesterday was that the Supreme Court materiality was in effect in the final release as compared to the proposing release was added as the trigger on greenhouse gases. The original proposal said you had to disclose Scope 1 and Scope 2. The final release says you have to disclose those if material, and the material word is the Supreme Court word. So, I mean, just to clarify in what you were addressing on that. Preeti, on SAB 99, the first 2/3 of SAB 99 are about what we've been talking about. There's a further third. Lynn referred to Part 1. There's Part 2 of SAB 99. That is all about intentional statements that are, immaterial statements that are intentionally made. I mean, this whole fraud thing, a third of SAB 99 is telling you how to deal with fraud and what auditors have to do under Section 10A. So, I think SAB 99, I didn't talk about it in the introduction, but it deals with fraud. I mean, it's got the whole thing in there. I also, you made the statement that companies, audit committees are pervasively waiving errors. I haven't done, obviously, anywhere near the kind of research that you've done. Mine's just what I see every day. But at least the data set in your main study that was done here was 2004 to 2014. And I think you looked at 3,000 audits, so that's a big data set. My sense is that today, and just what I see in every day in terms of errors in working with audit committees, I'm talking about immaterial, unintentional errors, that I don't think that the errors are being pervasively waived at this time. And maybe that would suggest that, at least to me, that before we go too far on this, that an update of the data set would be worth doing, because, I mean, to me, I feel like the audit firms are doing a more robust job at looking at errors, and I think audit committees are, frankly, just a little bit scared today. They don't like having errors when they're doing their job. So I think an update to see whether what I'm seeing anecdotally is actually the fact would probably make sense in that way. And Lynn, it's hard to have any comment on what you said. You covered it all so much better than I did that I won't further comment.
I will say, John, you're right about the whole second half of the SAB 99 is about intentional fraud. Interestingly, it is in part in there because of a registrant that sells a sandwich called the Big Mac, where numbers were intentionally getting adjusted wrong and people weren't stopping it, and it's exactly what Joe talked about. It was a small amount initially and then got to be a big amount. When it got to be a big amount, that was such a big client to their auditors that their auditors actually told them no, but said they'd still issue the audit opinion. And as a result, we wrote Section 2 of the SAB 99 to prevent that from ever happening. In fact, I went to bed that night. I called the CFO up. He didn't answer, and I said, I want you to call me back in the morning and tell me what you're going to tell the investors when you have to tell them about this. Never got the call back, but I read in the Wall Street Journal they were restating their numbers the next morning.
So, Preeti, what are your thoughts?
Yeah, just if I can give a little more context to the study. So the study was, as John mentioned, from 2004 to 2015. We found that of the just over 2,500 actual audits of real public companies we looked at, 18% had no errors. 41% of our sample waived all errors, all of them. Only 10% of the sample corrected all errors, and the remaining 30% corrected some but not all errors. So when I say that there is pervasive waiving, I think it's helpful to understand the percentages. Specifically, there was a small number that waived errors in excess of materiality. Less than 1% of the cases, but these resulted in restatements at the rate of 12%. Okay, so 22 cases specifically waiving in excess of materiality. Now, there's two interpretations to that latter part. One possibility is that people have just misapplied the guidance. Okay, another possibility is that they're using contextual factors to justify waiving quantitatively large amounts. And I don't know the answer to that because the study didn't get into contextual factors. We didn't have, the information to do that. Now, to expand on this, yes, the sample ended in 2015. It began in 2004. This is after we had the pervasive problems that Sarbanes-Oxley was meant to address. So, frankly, I wasn't expecting 50%. I was expecting more like 10% waiving all. So the fact that I found 50% after all of this legislation, all of this tension, all of these problems that ensued between 2000 and 2004 was frankly shocking to me in terms of my personal belief revision. You all can decide for yourself. In the study, we have put in factors to address differences by audit firms, differences across time, and we didn't find any pervasive evidence that suggests that these errors have decreased over time or the behavior has changed over time. Now, I certainly can't speculate what happens after 2015, but what I am concerned about personally, as someone who is an investor in the market, is people tend to claim they find religion about these things from time to time when it's convenient, when bad things happen in the market, and then they forget again. So if you don't have any pervasive checking of this or training on this issue or implementation guidance, then this will happen again. That's my belief.
So help me understand something. So basically, this is when the people involved, the registrant, the auditors, everyone knows what the materiality standard is, and it's still violated. So what happens then?
Well, the likelihood of having a restatement goes up, right? And as Joe mentioned, you might not be quite there yet, but then if some other issue comes along, then all of a sudden you're pushed over the ledge, right? And what I'm concerned about also is I don't understand why each and every one of them didn't have a material weakness opinion. If you have an actual error of that large magnitude, then there should be no question a potential error could only be larger. So is it happening pervasively? No, but it is happening that people are not following the rules.
Yes, John.
I got, when this whole discussion started, I actually went out and started talking to people. I don't represent audit firms, I represent companies, but I started talking to my friends at some of the audit firms to find out how they were doing this. And first of all, they now, under the PCLB rules, put together a list of errors that are not corrected by management when they have done the audit, and that goes to the audit committee, and they review those through. They're heavily documented, whatever they've put on the list, and then they talk those through with the audit committee. If you look at these errors, as I understand it, large numbers of them are, yes, they're errors, but they're not the kind of thing that you would be concerned about, in my view, in the sense that in one sense, they're self-correcting. But let me just give you the two examples that I, kind of heard the most. You're coming up to the end of the period. Okay, the company is. They will make an estimate with respect to the last 2 weeks of the quarter of something, because they need to close the books. They need to book results. So they make an estimate for the last 2 weeks. The auditors, when they come along and audit, they've got, that's a month after you've closed the books. They see that there may be a difference between, they may find a difference between that estimate and the actual, because the actual is now available. The difference is immaterial. And, you don't go back and, in effect, reopen the books as you're closing it. You just let the error self-corrects itself in the next period. It's immaterial, but that is apparently one of the large categories of error. Another category is if you're using, the auditors are looking at a sample of things, so they are sampling. So off of that sample, they will do some calculation of what they project the actual number should be based on the sample. If that but by the time when the auditors look at it, when you look at it later, you've come up with that number is different than management's number, the number that they've calculated off the sample. It's immaterial. Are you going to go and correct for that? You could, but you wouldn't necessarily need to. Again, it just, it will self-correct itself as you go forward. Joe, I know I can see you jumping in on this,
look, again, you're absolutely right, John. This is a very, very common pattern. And, when I deal with it, what I actually do is I wind up looking for serial correlations. These things, if they wind up happening, should basically be random. Sometimes we're off a little bit because we're north, sometimes we're off a little bit because we're south, and as long as you don't see a pattern evolving, this stuff happens. Right? You're not going to have everything right to 12 decimal places every time. You can't. It's impossible. You ask people to do the impossible, it's going to fail. But the additional level of scrutiny that I bring to these issues is basically saying, are they always fudging in one direction just a little bit? All right. So I agree with everything that you're saying, but I'm always looking for that little bit of fudge. right? And as long as I don't find any fudge, I'm fine with it for all of the reasons that you say.
And that's what an audit committee should be doing. I agree
Yeah.
entirely. I'm just saying that you sometimes have errors that you
Right.
you don't feel the need to correct. I mean,
You're doing a beautiful job explaining a situation where you have sub-material errors that you don't need to worry about them metastasizing or becoming problematic, provided they're uncorrelated over time. Yep.
Yes, Lynn.
The chief accountant of the SEC did a speech back in the spring of 2002, and it was a marvelous speech.
22.
Yeah. If I misspoke, yeah, it's 2022. And so what he found was that companies and their auditors were fudging with respect to whether some of these restatements were big enough that they had to go fix financial statements in the past or not. And it was a very disturbing trend. And that would be supportive of what Preeti's findings are. I've seen some of that myself. In the UK, they went in and their FRC, what they call their Financial Reporting Committee that regulates their corporate governance and financial reporting and auditing, accounting over there, they went in and did a sweep series of exams of a significant population of financial statement audits. And they found that in more cases than they wanted to see, the companies and auditors had made incorrect decisions about what was or was not material. And their rules, in the same ballpark, their international rules, approximately the same ballpark as what ours is. But when they did an exam, and this is in recent years, they found problems like what Preeti is talking about for companies listed in the London markets. And they put out a report citing their findings. And then they put out some pretty good training materials. They're very critical of the audit firms, required the audit firms to start training inside the firms on materiality, because it's not something you get a lot of training on inside an audit firm, and took action. And then the International Federation of Accountants, which is the global organization of accountants, put their own training materials out in this area. And again, my experience have been there's not much training in college for a student coming out that's going to be an accountant or auditor. There's maybe a page in the textbook on materiality, so you don't get that training about how to make those determinations and come up with the numbers. The audit firms don't do much training on it. And I think what you're hearing talked about is, and Joe's concerns, Preeti's concerns, there is some evidence that problems are out there, which is the problem that led us to do SAB 99 in the first place. And you have to be worried with the frothy high valuations in the markets. Are we getting ourselves headed in the same direction? You wouldn't want to see that happen. That's why I'm kind of a fan of going back to doing what the UK did to put transparency in. At least when they did the sweep exams, they knew they could identify the audits and had how the auditors made the determination, the number, and could focus in on where they hadn't done it right, and told the auditors shape up and get it right next time. It's not
but
a
Lynn,
bad
you're talking about
exercise.
implementation, not changing SAB 99.
Right.
Yeah.
That's exactly right.
By the way, I mean, this is what Preeti studied, but there is a schedule of unadjusted differences that is created with respect to every audit, and every audit the PCAOB inspects, They have that
There
schedule of
is.
unadjusted
Let me just clarify a little bit of information about that schedule. So that schedule is a requirement by standard to create that schedule that the audit committee reviews. It states that anything clearly trivial, which is typically defined as 3 or 5% of materiality, can be omitted from the schedule. So we already don't have really tiny things even showing up on the schedule, which means they weren't showing up in my sample. Those things that are left off the schedule were not part of my sample. Okay, so first point of clarification. Second point is the definition of a misstatement following the standard is from the edge of whatever, let's suppose an estimate is made by management last 2 weeks, typical thing, as John mentioned. What an auditor is supposed to do is say, here's the reasonable possible range of that estimate from, let's just call it $10 to $25. Okay, I'm just putting numbers on it. The auditor says, hey, there's an error only if you're outside of that range, not at the midpoint. Okay, so we're already starting at the edge of what's acceptable when we define what is a misstatement. Okay, a second point is that the standards also say you're not supposed to use ex post actual information to create an error. You're supposed to look at the information that was known at the time that the judgment was made, and that is how you make an error. So I don't think the exact scenario that John describes actually captures what is on that list, just as a clarification.
Okay, thank you very much. I would like to turn to some of the committee members to see if they have any questions. Yes, Sandy.
Yeah, I have a couple questions. That was good, and I Lynn's comment with respect to the FRC is why we advocated for disclosure and transparency with respect to the materiality assessment. Acting Chair Lee, in I guess it would have been 2021, somewhere in there, published an article which we actually cited heavily in our climate comment letter to the Commission in 2022. And there's a great, it's Living in a Material World, and she goes about the myths of materiality. And one thing really struck me as a former audit partner and as a former preparer was the comment she made that the people that are making the materiality decisions have never met an investor, right? Or they might be them, but she doesn't say it quite that way. She says, you know, there's no investor at that table, right? And it gets to, does SAB 99 need to be adjusted, or does it in fact go to the training that you actually point to? Because you have people making these decisions who don't know how investors make decisions. One thing that, so I would be interested in, one, the comment with respect to should materiality be disclosed in the US, and that's like lighting a match and throwing it, I get it. But two, I also, with the advent of all of this discussion about ESG and climate and voting, the Supreme Court's decision says impact the vote of a shareholder. But as a former auditor and partner and discussing with corporate counsel, we never talked about how the investor would vote other than sell or complain. It's voting and financial materiality. And we live in a world where there's a whole lot more attention being played on corporate governance and voting, particularly in passive funds where people don't look at financial statements, than there is on the financial materiality that's being accumulated on these summary of significant audit differences or unadjusted differences that Preeti talked about, and all of the things that don't make it there. So I'm curious for you guys as to how voting decisions are incorporated or should be. SAB 99 doesn't mention vote, right? Acting Chair Lee's mentioned vote, and it's come up again because the ISSB says it's defined its materiality for sustainability in the same way that it's defined it for the IASB. And I said, well, the conceptual framework, they can include the definition of materiality in S1, which is a standard, not a conceptual framework. But for IFRS, the definition that includes materiality is in the conceptual framework, which is not authoritative. So they are not equal. So under sustainability, the materiality includes voting decisions. The Supreme Court decision includes voting decisions. But how, I've never seen an auditor include the voting decision in a materiality assessment related to a summary of unadjusted differences. So I'm curious as to if you think any adjustment needs to be made for voting decisions in the language to make it clear.
First of all, the Supreme Court decisions aren't just a voting decision because they extend it out to the 10B and the 10B5. So that notion, especially because the TSC is a proxy issue, has been asked and answered, and it's been expanded beyond that. When you talk about a decision that an audit partner would make, okay, it tells the audit partner they've got to think of what would a reasonable investor decide in this situation, and what are some of the things that one might consider. And if you read the court decisions, there's one in 2010 or more recent one that actually goes in and gives you more of the consideration from a person looking at investing.
I don't
And so-
disagree with what the law says. What I'm asking is that as a former audit partner, I never thought about voting decisions. I'm being honest. And I'm not sure that I've met a partner.
You have now.
Okay, well, you might have because you read that, okay? But I'm just telling you, in the broad spectrum of things, particularly how voting is taking place today without an assessment of financial materiality, to me it seems like there's room for analysis and discussion and consideration of that issue.
I can tell you that, and I've sat on a number of public companies as well, okay, boards, and I ask both the CFO and audit partner. Warren Buffett had sent us a letter at the time we did SAB 99. Arthur Levitt and I'd had a call with Warren, and he agreed to give us a letter on this issue. And Warren said in his letter there were 5 things that you should ask if you're on the audit committee. And in fact, on the board of Coca-Cola, if you go back and look at the annual report when he was on the board of Coke and on their audit committee, all 5 questions are in the 10K or in the proxy with the answers. One of the questions that he'd asked the CFO and the audit partner was, given what you know today about the company, either as from your role as CFO or for the audit partner, as all that you've known as you've gone through and done the audit, is there anything that hasn't been disclosed? That's his first question for the audit partner. Anything that hasn't been disclosed that, given what you know, you'd want to have disclosed if you were investing in this company? The second question that was follow-up to that then was, is there any number in the financial statements, if as an audit partner you were preparing those financial statements, is there any number that you would change in those financial statements? He asked the audit partner those questions, and their responses showed up in the annual report of Coca-Cola. So I can guarantee you that audit partner was thinking about investors when they made the decision on materiality.
But in the context of...
So I'm going to shift a little bit since we're running out of time, because I wanted to get to one question, because Meredith Cross mentioned that from their historical materiality panel, there was one issue that was worth discussing, and that is you addressed it, Lynn, and that is that of the reasonable investor. And so I wanted to turn to George to get a thought on the reasonable investor. Has the reasonable investor shifted in the last 25 years?
Yeah, I think that's a great question, and we have to remember that whenever the law uses a reasonableness standard, that is meant to provide flexibility and a contextual assessment. And so if the Supreme Court or if courts had a particular very strict notion of what the reasonable investor would look like, they would have embedded it in law, but instead, of course, they have preserved the notion of the reasonable investor. And what does that mean? I think my view is that the definition hasn't changed over the past 25 years, but certainly reasonable investor behavior has changed because we have to look at the investors today and what they care about and think about whether that, if all investors care about sustainability or if the majority of investors care about sustainability, and we think that that is not reasonable, then that's a very serious problem for kind of the investors that we have investing our retirement funds. And so if BlackRock, State Street, and Vanguard care about sustainability, then we have to assume that the reasonable investor cares about sustainability. And of course, sustainability, that's on a very general level, and there are many different topics within sustainability. And James, if you would allow me to pivot back to something that John said, which was, of course, very accurate in his juxtaposition of the use of materiality in the executive compensation disclosure rules promulgated in an entire framework in the 1990s, and then in yesterday's climate disclosure rule. And so my question is the requirement to use materiality as a screening device in Scope 1 and Scope 2 a good use of materiality? And what do I mean by that? Materiality judgments are expensive and costly because in order to decide whether Scope 1 and Scope 2 emissions are material, registrants have to perform some sort of an analysis. That analysis has to be defensible. If they get it wrong, that's a very serious problem. And so it will be interesting to see, I guess, 3.5 years from now, when we start getting the disclosures, how many registrants concluded that Scope 1 and Scope 2 are not material. And my prediction is that very few, and probably none, would have concluded that Scope 1 and Scope 2 are not material. And then at that point, we have to look at all the costs that were incurred by these registrants to do the analysis, aggregated across the entire market. And then we have to think, well, wouldn't it have been better for the SEC to have just concluded that Scope 1 and Scope 2 should be disclosed without particularized materiality testing? And then we also have to remember that, and this is also from the case law, TSC and BASIC, that we actually have a safety valve. Because if it turns out at the litigation stage, at the adjudication stage, that Scope 1 and Scope 2 were not material, or that the difference in if there was a misstatement were not material, then there wouldn't be liability, because a finding of materiality is a prerequisite to finding of liability at the adjudication stage. So that's maybe kind of one of the more provocative statements that were said today.
It's interesting because the SEC proposed it one way, got 24,000 comment letters apparently, and then adopted it the other way. I'm assuming that many people will assume that change, it could have been because of the comment letters. It is equally likely that it was a concern about legal challenge to the rulemaking. But obviously the SEC made a judgment to make the change.
Yeah, and was this a political expediency judgment, or was this a judgment about the costs and what is advisable?
So, and we're going to give the last question to Brian Helmer.
Okay, so when I listen to all this, and particularly this last conversation about the lack, we already know there's a lack of investor representation at accounting standard setting levels. There's a lack of investor knowledge within the audit community, and quite frankly, in the way that materiality determinations are made. And as a 35-year institutional investor, I see the impact of that. To me, my takeaway from listening to all of this, and it's kind of what George just alluded to, ultimately, at the end of the day, if we're going to get the information we need from publicly traded companies, it seems to me that an approach that require specific disclosures, preferably independent of materiality standards, is the only way we're going to get what we want. Does anybody disagree with that? Because that seems very common sense, my biggest takeaway from this conversation.
I would say it depends, Brian.
That's the best. That's the closest thing to an agreement I would expect from you, Lynn.
Yeah. No, it's a matter of, if you're talking about under the current law, no, it's not feasible. It's just not what the law is. If you want to change the law, I actually agreed with the stuff that was in the proposed ESG thing, but didn't believe it complied with the law. I think the commission absolutely made the right decision yesterday with what they went with, because I don't think it would have been defensive. The original agreement or the original proposal never would have stood up in the court test. Some of the materiality stuff that was in the original one had no chance. And I'm a supporter of what was in there, but I also know that if they'd done that, it would not have lasted in the courts, and it'd been 15 years down the road before we got.
The way the compensation, information is gathered in the proxy, that we can require individual components of data that are individually non-material that help create the mosaic that ultimately investors need to evaluate the risk and understand the governance practices and understand the management incentives of these companies. So I'm not sure that's correct. I think that there is precedent for investors to finally make their voice heard and get the information that they want and, quite frankly, need from companies who are able to use materiality law as it currently exists to avoid disclosing specific things that under those rules aren't material but are important to investors nonetheless. And I think that's my takeaway from this, and I just wanted to share that, so thanks.
I can't help but comment that we were doing the executive comp rules in 2006. The issue that had the most attention is whether there should be a requirement to disclose Katie Couric's compensation. If you remember, there was a suggestion that you had to disclose the 3 highest paid people in the organization, even if they weren't in management. Obviously, for a variety of reasons, we decided not to include that in the final rule. But even in executive comp, there's some things that didn't end up in there.
So we're at the tail end, and given the topic, SAB 99, and the fact that we have Lynn Turner here, I will give you the last minute, Lynn. Do you have any closing remarks?
Yeah, I think transparency is a positive step that in a way addresses it from Brian's perspective, because you give the number publicly out to investors, how people got to that number, and then investors can then make an informed decision. And so I think that would be a way to go about getting the information that Brian wants. Unfortunately, given the situation we find ourselves in DC, the ability to go request whatever you want to request, a group, and get it is probably just not pragmatic and reality today. There's some things I'd like to have too, but I know in this environment that we're in, it ain't gonna happen, and I'm not the Supreme Court justice, so until I get there.
So I'd like to thank all of the panelists. Thank you very much.
On time. That was good stuff, given the breadth of the topic. Thank you. And thank you to the panelists for sharing your time and your thoughts with us. The next item on our agenda is we're going to, James is going to stay on the hot seat and up here with me, and we're going to turn our attention to a discussion regarding a possible recommendation on digital engagement practices and predictive data analytics. If I could ask Paul Roy to introduce that topic and bring us up to date on where we are relative to the last time the IAC discussed this at our previous meeting. That would be great. Thank you.
Good. Thank you, Mr. Chairman. As you noted at our meeting in December, we reviewed a draft recommendation of the Disclosure Subcommittee, and I'd like to acknowledge the committee members Brian Helmer, Christine Lazaro, and Sandra Peters. We deferred a vote on the recommendation until this meeting because the subcommittee wanted to refine and improve the draft's background discussion, including the discussion of existing regulatory requirements. The current draft, which the IAC members have and which is reflected on the IAC's website, reflects these revisions. So since there's been a prior discussion and review of the draft, I won't repeat an extensive overview of the recommendations. I would, however, note several points. First, while many industry commenters recommended that the Commission abandon and withdraw the proposal, this is not our recommendation. I want to be very clear on this point, as various parties citing our draft recommendation have mischaracterized our position. Again, we are not recommending that the Commission withdraw the PDA proposal. We believe, however, that the proposal addresses significant concerns regarding predictive data analytics, artificial intelligence, and problematic digital engagement practices, and addresses gaps in the current regulatory framework. We, however, recommend that the proposal be modified and key terms narrowed. We suggest that these changes would avoid unintended consequences and adverse effects on investors and not impede the adoption of new beneficial technologies. The rules we envision would be an overlay over existing rules and requirements, but be designed to align with these existing requirements, particularly regulation best interest and the advisor fiduciary duty interpretation. Specifically, we propose narrowing the scope of the definition of covered technologies to target the unique risk of predictive data analytics and artificial intelligence technologies. We also propose narrowing the definition of investor interaction to include technologies that interact directly with investors or that aid in that interaction with investors. We propose the rules use the current definition of a conflict of interest. That is an interest which might incline a firm to make a recommendation or give advice which is not disinterested. We further propose the rule incorporate or cross-reference the existing requirement under regulation best interest and the advisor fiduciary duty interpretation that the use of a covered technology that contains a conflict of interest not place the firm's interest ahead of its customers or clients. We also propose that the rule use the existing framework to mitigate or eliminate conflicts of interest involving predictive data analytics and artificial technology when disclosure is inadequate. To further protect self-directed investors, we include a recommendation to clarify the definition of what constitutes a recommendation under regulation best interest, providing that digital engagement practices designed to encourage frequent trading, engage in particular trading strategies, or to open particular types of accounts be deemed calls to action and therefore recommendations. So we believe with these modifications to the Commission's proposal that it will substantially increase investor protection regarding the use of problematic technologies. So let me respond to some of the comments that Commissioner Peirce made about the interaction among IAC committee members and the discussions we had. I can assure you that we had robust discussions on this proposal. And fair to say there was not unanimity. in terms of the recommendations that our subcommittee is recommending to the full IAC. And I think, I don't want to put words in the mouth of some of my colleagues on the IAC, but I think there were some philosophical differences in terms of approach. The PDA rule proposal really pulls away from disclosure as an option in terms of addressing conflicts of interest. We recognize that there are technologies that are so opaque and complex that disclosure is insufficient. But a number of us felt like a one-size-fits-all abandoned disclosure as an alternative just was a bridge too far. But there are others who suggested that in this context, we should move away from disclosure. Fundamental shift from what's traditionally been required under the federal securities laws. So with that, Christopher, I will stop and open it up for comments or questions.
Thank you, Paul, for that summary. If I could just ask you to indulge us for a minute longer and just give a quick description of summary of the changes between the draft that's being voted on today and the draft that we looked at the last meeting. That would be very helpful for
so
people.
I think when you compare the drafts, again, the bulk of it is kind of revising, if you will, and making clear what we think the current rules and laws are. I think the recommendations themselves are largely unchanged. We did some wordsmithing. I think we recognized there were some places where maybe there were overstatements, and we toned those down a bit. But in large measure, it's fundamentally the same set of recommendations.
To clarify, in terms of process, the changes were driven by internal IAC discussions and feedback from your colleagues who came across the spectrum on this issue. The changes were not in response to external input outside the IAC, were they?
No, I mean, we actually had, in December, we had a draft, a revised draft, and we felt like we'd be jamming the IAC to get them to consider that draft a day or two before the actual IAC meeting.
In other words, the previous draft was being worked on right up until the time of the meeting, and we chose not to vote on it because people wouldn't have had time to look at it. So the dialogue was continuing after the December meeting, and this draft reflects the final conclusion of those discussions.
That's correct.
Is everyone clear on that? Does anyone have any questions? Paul, go ahead.
Go ahead. Yeah, I was just going to make one kind of overarching comment because I'm really proud of how this process played out and where we ended up getting, and the decision to delay the vote in December, because I do think, you know, in all transparency, that the original draft is essentially the same set of recommendations that is meant to be supportive of the SEC's approach in their rule proposal, but to offer some opportunities to implement it in a way that we think is more practical, more efficient, and less potentially filled with unintended consequences. I also think it brings into play that expansion of the recommendation definition, which is not really part of the SEC PDA proposal, and I think that also has the opportunity to protect investors. So I'm proud of all of that. I'm proud of the improvements that we made, and a lot of, Christopher, you asked what the changes are. Beyond clarifying some of the background material, which just as we're not all securities lawyers, so I'll take some of the blame for that. But I think we got the facts about the current status quo a little more clearly stated. I also think that we did need to improve the way the document came across from a tone standpoint, because it is so supportive of the general direction the SEC is trying to go. And I'm not sure in our quest to provide recommendations on how to make it even better, that it came across that we were really supportive of the bulk of the direction that they were going. And I think that thematically is what maybe allowed, I mean, I never know what people's intentions are, but some of the mischaracterizations of this proposal, I think, could have been attributed to the the tonal structure of the early supporting parts of the document. So I felt it was important to improve that. We worked really hard on improving that, and I'm really pleased with the document that we put forward. I still recognize people may not, there might not be unanimous support, but I was really proud of the collaborative nature, and I think it speaks to the best of how we work together. So I'm really happy with that.
I have some similar comments, but I'll put myself in the queue behind Paul.
Yeah, and I want to thank the entire commission and the staff for putting together the original recommendation, and then thank my fellow committee colleagues here that really spent a lot of time and sincere effort that goes back far beyond what was originally put forth publicly last summer by the commission, really holding varying panels that hit on topics of digital engagement practices and ethical artificial intelligence and predictive data analytics and so forth. And this is an important topic that we as a society face. I know just this week there's some concerns of what artificial intelligence might be spitting out, of course, outside of the jurisdiction of the SEC here. So I just really want to thank everybody. This was an incredibly thorough review, as Paul and Brian have already noted, that we in this voluntary committee have spent a lot of important time to put forth, and sincerely reiterating what everybody has already said, that we strongly support the spirit and the intent of the original regulation proposed last summer, and that with a couple tweaks, we hope this can be implemented to support and protect investors.
Thanks very much, Paul, and I concur. Speaking for myself personally and my own reasons for supporting this recommendation, I share the SEC's inclination to take a heightened regulatory approach with respect to these complex and dangerous technologies, many of which have not only the potential to have sort of deeply buried latent conflicts, but also have tremendous reach to the extent they're getting out through digital means like application platforms and so forth. So I'm very, very sympathetic to the urge to regulate and very supportive of it. And I think this is an emerging new category that really does require heightened scrutiny and a lot of attention. So I have no issue there. I also, however, look at these technologies through the lens of access and inclusion. And I do think that properly regulated and designed in a manner which allows audit so that we understand what's in the algorithm, these tools do have the ability to bring the cost of investing down and open access to markets and allow self-directed investors to access and participate in the market in situations where they either would be going it alone or couldn't afford to work with an advisor because they don't meet the minimum account sizes or so forth. So when I take a balanced view at this, I like the recommendation because it says, hey, we agree with the impulse to regulate, and we acknowledge the dangers here, but we suggest that we not, really the manner in which we regulate be moderated so that it doesn't exclude technologies which really could be beneficial if properly implemented. So that's my 2 cents. Other thoughts?
Thank you, Christopher. So first I have to begin with a disclaimer. The remarks I'm about to make are provided in my official capacity as the investor advocate of the Securities and Exchange Commission, but they do not necessarily represent the views of the Commission, the commissioners, or other members of the staff. The first thing I want to do is I also want to extend my thank you to everyone on the IAC who's worked on this recommendation before us this afternoon. And I especially want to note that I appreciate, as you noted, Paul, that everyone was willing to recommit the earlier version of this recommendation for further work when lack of consensus emerged during our December IAC meeting. I said during that meeting that diverse viewpoints are very desirable in an advisory committee, and I hope to see more discussion and debate on our recommendations in future meetings. I said then, and I'll say it again, I think that's healthy. I also recognize that the subcommittee has made several improvements to the analysis of the recommendation. And I value the added clarity. It's the work is definitely clear where that's been added. However, I am unable to support the recommendation for the following reasons. First, I do appreciate several points made in the analysis with regard to the proposal's definition of covered technology. And I can also agree that the definition may be overbroad and inadvertently reduces the benefit of some technologies for retail investors. And this is something that we've discussed in the past. As Paul also notes, we've had very robust debate. But if covered technology were to be successfully redefined to focus on the use of exceptionally complex and opaque technologies, including artificial intelligence, predictive data analytics, neural networks, and related or emerging technologies, then it is my view that firms should not be permitted to address conflicts of interest associated with those covered technologies through disclosure alone. I support requiring firms to eliminate conflicts or their effects when the conflicts are the result of covered technologies. It's my view that this is the more effective approach to protecting investors for several reasons. First, I question what it would look like to provide full and fair disclosure of conflicts of interest that result from exceptionally opaque and complex technologies. Research that our office, the Office of the Investor Advocate, published last year on the efficacy of disclosures that were related to highly complex retail investment products strongly suggests to me that an enormous effort is required to make these kinds of disclosures successful. It is not at all obvious to me that disclosures regarding conflicts that result from complex and opaque technologies will not, in and of themselves, be complex and opaque. This makes me especially, but not uniquely, concerned about how self-directed investors will receive and understand these disclosures. Given the welcome growth, which you note, Christopher, in new investors, many of whom are self-directed and are using digital platforms to invest, it seems reasonable to me to give extra attention to the problem of fair and full disclosure when investors are acting without the assistance of a financial professional. Further, I'm concerned that due to the scalability of covered technologies and the potential for firms to reach a broad audience at rapid speed, that any resulting conflicts of interest could cause harm to investors in a more pronounced fashion and on a broader scale than has been previously possible. And so here, too, I question whether reliance on disclosures regarding conflicts that result from covered technologies can be reasonably expected to address the different scale of investor harm that is now possible. The last thing that I want to say is it's also my view that the requirement to eliminate conflicts or their effects builds upon existing regulations and does not represent a dramatic departure from firms' existing regulatory obligations. On the contrary, eliminating conflicts or their effects is consistent with obligations that investment advisors and broker-dealers have now. They may not place their interests ahead of the interests of their clients. So with regard to that point, I specifically want to say that I do not share the concerns stated in the recommendation that the proposed requirement to eliminate conflicts or their effects, quote, takes these technologies into a regulatory realm that is beyond decades of the SEC's own guidance for investment advisors and broker-dealers. And with that, I thank you for letting me share my views.
Christina, thank you for that input. Other comments, questions? Brian?
Just real quickly, I want to clarify the record because we do a whip count before every vote. There was not a lack of consensus. We pulled it because we thought we could do better, not because there was a lack of consensus. So I just want to clarify that.
Yes, Leslie.
I just wanted to make a little statement as well. I want to start with a sincere thank you. I appreciate the time and effort that has gone into the drafting of the revised version of this recommendation. As always, Paul Roy, Brian Helmer, and Christine Lazaro were fearless leaders, and I'm grateful for their engagement. They met with me on several occasions to go over these things. Respectfully, I cannot support the recommendation. As I will explain, I firmly oppose 2 of the IAC's 5 recommendations, and I have concerns with some aspects of the remaining recommendations. A key consideration in this is my desire to address a longstanding concern, conflicts of interest, from a more holistic and realistic perspective. At the outset, I acknowledge that regulators are in the early innings of the work to align the regulatory framework more fully with the fast-evolving use of technology by broker-dealers and investment advisors. I believe that we as regulators should approach this transition as a moonshot. A moonshot approach probably would cost less money and time overall for regulators in the industry than continual minor changes every few years. Moreover, I feel that if we do not make a major change soon to our framework, we will lose the trust of many investors. I generally believe the SEC should pursue a final rulemaking that is broad, dynamic, and evergreen in scope and nature. Obviously, the Commission should continue to gather facts and right-size the rulemaking. But generally, I fail to see the value in writing a narrow rule or rules that will be outdated before the industry has even implemented them. Further, I respectfully think we need to acknowledge some historical and present context for our work. As we may all agree, disclosure has become less effective as a tool for conflict management than it was 20 years ago. This is due to factors like increasing complexity of our markets, participants, and products, as well as competition between disclosures and the increasing amount of other information that we as Americans consume daily. While investors have long struggled to comprehend conflicts on a relationship basis and a transaction basis, the struggle has only become more acute with the collision of the information age and our increasingly opaque, complex markets and ever-growing menu of investment options. As I stated, I firmly oppose the first 2 recommendations. In a nutshell, I believe the facts and circumstances, including lessons learned, investor behavior, and the pace of innovation, all counsel against continued investment in a mostly analog regulatory framework that has long suffered from opacity, complexity, and conflicts. To begin with, on page 10 of the recommendation, the IAC calls on the Commission to, quote, narrow the scope of the PDA rule proposal to target the unique risk of predictive data analytics and artificial intelligence that interact directly with investors, end quote. Here, I believe the IAC is using the term directly consistent with the definitions offered in the SEC's proposed rulemaking. There, directly refers to the uses of covered technology in an investor interaction that occurs directly through the use of a covered technology. An example is a behavioral feature on a platform that is meant to prompt or has the effect of prompting investors' investment-related behaviors. By contrast, indirectly refers to firm personnel using covered technology and communicating the resulting information gleaned to an investor. An example given by the SEC is an email from a broker recommending an investment product when the broker used PDA-like technology to generate the recommendation. Next, on page 11, the IAC calls on the Commission to, quote, build upon the existing regulatory framework which requires firms to eliminate, mitigate, or disclose conflicts of interest while recognizing that for certain inherently opaque and complex PDA and AI technologies, disclosure is not sufficient, and use the existing definition of conflicts under regulation best interest and the advisor fiduciary duty interpretation, end quote. My first concern is that the recommendations would undermine the primary benefit of the SEC's approach, which is to transition us to addressing associated conflicts at the earliest opportunity. To me, it is important to address conflicts earlier. The industry would benefit because they would avoid purchasing, designing, or developing technologies or practices that are non-compliant or otherwise conflicted or bad for business. Investors would benefit because any inadvertent harm against them has been avoided or minimized. Overall, our markets would benefit because we would foster trust among the participants. I am mindful that the industry is concerned about costs. So are regulators. Based on my experience, I believe the costs would decrease over time and overall be less than our present approach. Also, in all likelihood, many registrants can leverage existing procedures because they are already assessing technology uses for compliance with non-securities laws, such as data privacy laws. Second, I believe the final rulemaking should cover both direct and indirect investor interactions. In my experience, most investors use a mix of paper and digital sources and tools, including an occasional recommendation or advice provided by an associated person. This is both in response to and a driver of the fact that many financial firms now offer a menu of brokerage, advisory, and hybrid arrangements with and without varying levels of human engagement on investment strategies, advice, and recommendations. We need a final rule that takes a multifaceted approach rather than a binary approach. Third, I believe a final rulemaking should transition us away from a legal definition of conflict of interest that invites the industry to continue delivering conflicted advice and recommendations. In my experience, many newer investors are increasingly mistrustful of our markets and private and public institutions that serve them. Pursuing a final rulemaking that aligns with the expectations and behaviors of investors would be, in my opinion, a better approach for all. As I wrap up, I want to acknowledge that certain content has been added to the revised recommendation. Specifically, on page 14, it reads, quote, "We recommend that the Commission rely on existing regulations and principles to improve the oversight of digital engagement practices by clarifying the definition of what constitutes a recommendation," end quote. I agree that clarification is needed when it comes to recommendations. I think the IAC is right to encourage the SEC to be clearer that DEPs can be recommendations. We as state regulators are actively examining options for additional clarity as well. Importantly, I do not agree that regulators should categorically carve out so-called informational or educational DEPs from recommendations. Doing so runs the risk of creating a loophole that would undermine any educational benefits that may be provided through DEPs. I want to recognize that the IAC has discussed digital engagement practices a lot. I want to repeat a point because I think it may have been lost in our robust discussion. Specifically, I generally support the SEC's broad approach to the definition of covered technology. As proposed, it includes, and I am oversimplifying here for brevity, most digital engagement practices, predictive data analytics, and other kinds of technology presenting conflicts. If the Commission were to narrow the scope of covered technologies in the final rulemaking such that selected DEPs were carved out, I would still believe that our securities laws should treat most digital engagement practices as recommendations. In closing, I believe this is an opportunity to set up investors for greater success. I believe a rule that takes a bold approach to remove conflicts from tech at the design level is a great step in that direction. We should never take the trust placed in our capital markets for granted, and that includes the trust increasingly tech-savvy investors place in the technology and tools they use to invest and save for their futures. Thank you again, and thanks for your cooperation on this rule.
Leslie, thank you for those very thoughtful comments. Do we have any other comments or questions? That brings us to the point where it's time to vote on this recommendation. Is there a motion?
So moved, Christopher.
Is there a second?
Second.
All those in favor of passing the recommendation as circulated in connection with this meeting, say aye.
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 All those opposed?
Aye.
Abstain.
Thank you. Darn thing keeps turning off on me. The recommendation has been approved and the motion passes. That brings us to the next item on our agenda, which is the subcommittee and working group reports. Before I do that, I just wanted to acknowledge that we did do some important administrative work during our administrative session, including an election for a couple of positions, and I expect to be able to communicate the results of that to everyone probably as early as this evening, but certainly this week I'll get back to everybody on the outcome of that. So James, can I ask you to go first and give us a report on the Investor as Owner Subcommittee?
Thank you very much, Christopher. The Investor as Owner Subcommittee met and had a few ad hoc meetings in part to prepare for the Materiality panel. More recently, we've entered discussions to consider another panel in June out of the recommendation of commissioners, which involves great investor interest. So we are also contemplating working on that as well. Thank you.
Questions for James? All right, stay right up here in the neighborhood. You want to give us an update, Andrew, on market structure?
Sure, thanks, Christopher. So the Market Structure Subcommittee has been meeting over the past few months to go over the scope of the panel that we had this morning on equity market structure. And so as a part of that, we have discussed that in the future, we would like to also have a discussion as well on the options market, which has many of the similar issues at play, except we have different participants, and then there are different kind of factors at play there. So we want to be able to continue to discuss that in future subcommittee meetings, and so we can decide whether we want to hold another panel on that issue. And then separately, the subcommittee has also been discussing some of the private markets panels that we have been holding recently, and we will be in touch with the other subcommittees as well as to how to move forward on recommendations, both related to the ones that we've had recently and previously related to what the scope is for the recommendations, and also how they interact with one another, since we did have multiple panels that looked at both the accredited investor definition, but also talking about some of the disclosures and similarly investor protection in the private markets. So we will continue those discussions.
Thank you very much. Any questions for Andrew? Jamila, can we get an update on investor as purchaser?
Yes, thank you, Christopher. Our committee has been working hard to develop the recommendation that we're coming with based on our financial literacy and financial panel that we had that was so robust a few months ago. So it's coming. I don't want to promise June, Christopher. I'm hedging with September, but it's in good shape thanks to Alice and Alyssa, as well as Ted being very much involved in that one as well. We welcome feedback, early looks at any point joining one of our subcommittee meetings. We also have been very much supporting Paul and the working group for access and inclusion. A lot of us are in that working group and trying to make sure we stay close, obviously being investors, purchasers. So we'll continue to talk through issues and make sure all the recommendations that we look at are very related to that. I mean, obviously financial literacy is so closely aligned to what we're trying to do in that working group. And then finally, like Andrew said, a number of us have been trying to participate with Cambria and Leslie, trying not to get fully engrossed, but dipping our toe in, giving comments, certainly submitting the survey, ladies, for your recommendation. We're excited about this one. We have some very strong views, and so we look forward to helping see that one through as well.
Thank you, Jamila. Questions for Jamila? You're not trying to run the clock down on me,
No,
are you? Okay.
no.
All right. Okay. All right. I got my eye on you. Brian Helmer, can we get an update on the Disclosure Subcommittee?
Yeah, I mean, as you can tell, we've been focused on bringing a revised and improved version of the DEP recommendation on, and so that was our primary focus. As we look forward, we are working on, I like the way Jamila framed the work they're doing on their recommendation. We had a panel discussion on improving outcomes for self-directed investors and providing increased protections. That is something that's in progress. We hope it's ready in June, but I don't think we should promise that.
Oh, here we go again.
And then we continue. The subcommittee is very energized, consistent with our little role in the world disclosure subcommittee, to maybe take a look at a very kind of high meta level at the disclosure framework and how we might be able to improve it with very kind of broad brush strokes that take a look at it, maybe not through the lens of any specific issue, although we might get there. So we'll see where that goes. It's in early stages. If people have input into that idea of trying to, I mean, the basic idea is what would we focus on that might provide some high level, broad recommendations around improving the way disclosure gets used to protect and improve and help investors.
Questions for Brian or comments on that topic? You can either make them now or take them offline, either one. Okay, we're getting close. Paul, can I get an update on the working group on access and inclusion, please?
Yeah, you sure can. Working groups met twice since our December meeting. We always try to see if we can focus on access and inclusion topics, make sure that they're top of mind for the IAC. Jamila noted, we've been engaged with various folks on the investor education panel, self-directed investor, access and inclusion implications, possible changes to the accredited investor definition, again, raising access and inclusion issues. I just wanted to highlight the fact that the working group recommended and the IAC approved a letter to the SEC's Office of Minority and Women Inclusion supporting their recently approved changes to the diversity self-assessment tool, which invites regulated entities to complete and submit voluntary self-assessments of their diversity policies and practices. The letter encourages SEC-registered entities to submit these self-assessment reports because the data and information is critical to monitoring progress and trends in the securities industry regarding diversity, equity, and inclusion. Unfortunately, in 2022, the last time the office requested those reports, only 9% of entities submitted reports. And we hope that the revised tool will encourage more registrants and members to submit the reports in 2024. So that summarizes my report for the Access and Inclusion Working Group.
Thank you, Paul. Any questions for Paul on access and inclusion? Terrific. I think that letter's on our website if the members of the public are interested in looking at it. Well, that concludes our subcommittee and working group reports and brings us to the end of this quarterly meeting. I'd like, as always, to thank Christina and Danielle and Tony and Carla and Mark and the full supporting team of SEC staff who really do all the work and help us do the work that we do. So thank you for hosting us and for enabling us to have this meeting. We are adjourned.